Tim Kapel. How you doing today?
I'm doing well, Daryl. Thanks.
So you're an attorney, but you're also a professor at Loyola University in New Orleans. You're teaching basically law related to music and media. And you just participated as the lead attorney in a very important case. Let's talk about that because it has ramifications for musicians, publishing rights, and all that kind of stuff. So let's get into that.
Yeah, absolutely. Well, first, thanks for having me, and I appreciate being on. This case involved something of like what may seem like an esoteric provision of the Copyright Act that has to do with what's called termination rights. And termination rights are a congressionally provided mechanism by which authors or their heirs can recapture copyrights that have previously been transferred away. And in one iteration or another, these rights have been around since the nation's first Copyright Act in 1790. Congress has been providing authors and their heirs the ability to reclaim copyright. And the reason is pretty simple, and it's Congress has recognized that typically an author is transferring away his or her rights at a time when the value of that copyright is not known or simply not knowable. And so that on top of the bargaining power disparities that I think we recognize as bargaining power disparities between major, labels and publishers and individual creators, have prompted Congress to be fairly protective of authors and have provided that mechanism by which they can get their rights back. The issue in this case was an industry practice that had gone on for a long time, where after an author or their heirs exercise their recapture rights or their termination rights, the prior owner would, in this case, a music publisher, would take the position that those rights were limited to the United States. In other words, they would maintain the right to exploit the work everywhere in the world except the United States, and the author or the heirs only received back the right to exploit the work within the United States. And so it would have the effect of splitting up the copyright ownership based on territory.
Right, based on
Um,
region and
yeah, based on region. So, when I transferred you my copyright, I gave you the right to exploit it throughout the world. And now when I get it back, it's been splintered up into all these different
right.
pieces. And ultimately, what it did is provided a disincentive, or that industry practice provided a disincentive to terminate it all. Because what the labels or the publishers could do is essentially say, well, you could terminate, but you're going to be stuck under the old deal for, international revenues and rights. So why don't we just give you a little bit better of a deal all around, right? And then you don't agree not to terminate these rights. And ultimately, from a financial perspective, oftentimes that made a lot of sense. And also, I mean, and let's be honest, litigation is expensive, and so if they can make it so it's not worth your while to pursue a claim,
Right.
then you won't pursue it. And that's essentially, in our view, what's happened over the past 50 years is they've been smart, and the industry's been smart about making it not worth your time or money to pursue a claim. But Cyril, my client, Cyril Vetter, uh, was unwilling to accept that premise just on principle alone.
Yeah, and it's the inequity has obviously been the issue because attorneys, well, actually labels have several attorneys typically. They have you would think major labels have a lot of money. They know how to shut you down if you want to go after them. So like you as you mentioned, oftentimes they'll just make a deal, or sometimes they just won't make a deal. They'll just make you go after them. Has that been more typically the case, or what's been your experience with that?
Yeah, I mean, I think that we have to separate it between, publishers and record labels in this instance because
Right.
they've approached termination rights a little bit differently. In fact, the company line with most record labels is that these recordings are not eligible for termination in the first place because there's what's called a work for hire exception to
Right.
termination
Yep.
rights. And so if a work was one that was created for hire, then you don't have any termination rights. And so that copyright is perpetually owned by whomever you created it for. And so the record labels have historically taken the position that the sound recordings created by their recording artists are works for hire. Um, but the publishers have never really taken that approach. And so uh, whereas the labels might push you to fight a little bit harder, the publishers will most frequently just make you a deal. And I'll say that some of this is naturally becoming less important in our industry because ownership deals are becoming less frequent.
Right.
What since I started practicing, 15, well, more than 15 years ago now, and in that time I've seen the industry shift tremendously from, you know, almost purely ownership-based deals at the major label level um, to a lot of license-based deals now. And
Hmm.
when you have a license deal, you don't run into these same sort of termination issues because the expiration of the license will naturally return to the author or whomever the heirs are the right to exploit that work. Same goes in the publishing world. You had publishers like Cobalt and Downtown and other administrative publishers come in the past 2 decades and say, we aren't going to take ownership over your song's copyright. We just want to administer it for a certain period of time. And so, in some ways, these deals are becoming more of a relic, but they're very important for people in the 70s, 80s, 90s,
Right.
and
Like a
2000s.
legacy artist is where that's where it
Yeah, I
really
mean,
really hits home with them, right?
absolutely. And there's nothing to say that ownership deals won't come back in vogue at some point. And some of the deals we do are still straight ownership deals, and not everybody's going to get a license basis. And so these termination provisions are still very important, not just to legacy acts, but also to folks who are doing copyright transfers, even today.
Yeah, and it's a I mean, explain the difference if there is a difference between publishing and copyright because that's an area that a lot of people have confusion about. They don't understand if there is a difference. Talk about that a little bit for artists that are out there.
Yeah, I mean, sometimes the problem is we use the publishing as shorthand for the control, ownership and control of the musical work copyright. And most artists out there know that there are two separate copyrights and a recording. There's the recording itself, and then there's the underlying composition or musical work that's embodied on that recording, and they receive separate copyright protection with the law. Um, we have started to refer, we've commonly referred to the musical work copyright as the publishing, but really what we're saying is ownership and control of the musical work.
Hmm.
So I often encounter songwriters and creators who have this misconception that there's like a quote songwriter share or writer share of the copyright and a quote
Exactly.
publisher share. That's just not correct. The reason that people think that is pretty natural. It's because they're familiar with the split of revenue that occurs at the PRO level. So ASCAP and BMI and CSAC have historically split revenue into writer shares and publisher shares. But that doesn't mean that a copyright is split up in that way. There's only one copyright, and so if you are taking 50%, if you're a 50% writer of that song, then you've got 50% of the entire copyright, whether it's publishing or writers. It's just not helpful to think of it in those terms because too often, people think, oh, well, I'm keeping my writer's share, but I'm transferring my publishing. That just doesn't make any sense. It really stems from the way that PROs distribute revenue. So I always encourage um, creators to think of the song's copyright as a unitary thing. How are you going to split it up, right? Don't think about this share for this role or that share for that role. How are you going to split up this pie? And that's what I would encourage people to do. But yeah, that's the sort of the difference there.
Yeah, and I asked that question because there's a lot of, as we know, a lot of amateur musician attorneys out there, and it creates a lot of confusion. People have, they think they know how to protect their songs, how to protect their music properly, and they actually don't. Speaking from an attorney, a music attorney's perspective, what is the best way to protect your work from, well, I guess protect your copyright, but obviously from other people also stealing your work? What is the best way to do that?
Yeah, well, I mean, one of the great things about our copyright law is that it protects the work from the moment it's fixed in a tangible medium. You do not need to file anything with the government in order to have copyright protection. You do have copyright protection from the moment you create that work. Now, when it comes to enforcing that copyright in in the United States, we are somewhat unique in that we require the work to be registered with the Copyright Office in order to enforce it in federal court.
Hmm.
So a lot of times we can take pre-litigation enforcement action without a registration. But if it gets to the point where you need to enforce it in federal court, then you need to have a registration in order to do so. And lest you think that, oh, you can just register it, shortly before you go into court and file a claim, the law provides you with sort of carrots and sticks, right? So the stick is you can't get into court to enforce it unless you have a registration. But the carrot side of that is if you have registered the work prior to the infringement commencing, then you can avail yourself of special damages and including attorney's fees and what's called statutory damages. So whereas you don't have to prove how much you were actually harmed, the law just provides you, think of it as like a liquidated damages clause. So where, you're just going to get a certain amount, and that the amount that you would get can range anywhere from, $750 to $30,000 per infringement. And if it was willful, then it can go up to $150,000 per infringement. So, that's a really, large negotiating stick when you are pursuing somebody for an infringement claim. The thought that the potential defendant could be liable for statutory damages and attorney's fees usually brings people to the settlement table fairly quickly. On the other hand, if you don't have a registration at the time that the infringement commenced, you're more likely to get pushed back and sort of like, a game of chicken, kind of test the waters, see if somebody's actually going to pursue a claim. So enforcement and protection are two different things. But in general, I think it's a good idea to register your copyrights. It's not, it's not that expensive to do, and it's something that most people can do on their own. And so if you have the time and the resources to do it, I would certainly say to register it and register it early, so that if your work is misappropriated, you have a cause of action with some real teeth in it.
Hmm. And do you find, well, actually, a big part of the legacy artists, I'm a musician, I've worked with a lot of legacy artists, and a big issue for them is streaming rights and licensing, because with licensing, oftentimes really popular songs will show up in films. And let's talk about that for legacy artists, because I think that's kind of part of the case that you just did. And talk about the plaintiffs. I think Cyril Vetter was the plaintiff, and it was a song called Double Shot that you took on. Uh, Talk about that in terms of related to the licensing and then being able to recover funds once they get the publishing or copyright back.
Yeah, absolutely. And that's kind of how the dispute started is, as you point out, there was a sync license opportunity that was presented for this song. And the scope of that sync license was worldwide. In other words, the licensee in that case wanted, I'm sorry, the licensor in that case wanted to have the right to exploit the work throughout the entire world as a territory. The work was going, Double Shot was going to be used, or it was used in a television show called Moonlighting, which was actually from the 80s, but they wanted to put it on streaming services,
Ah, okay.
which did not have any geographical limitation on it, right?
Right, right.
And so they needed a worldwide license in order to do that. And my client attempted to license the work throughout the world because this was post termination. This was after he had recaptured his rights. And the prior publisher stepped in to say, no, we have the right to license it to ABC for every territory other than the United States. You only have the right to license it to ABC for the United States. And that's what kind
Right.
of got the lawsuit going. But to your question, in general, I always like to say that sync licensing is the most democratic form of revenue that a creator, has an opportunity to earn. Because a lot of these royalty streams, whether it be on the music publishing side or on the recording side, don't amount to much unless you've got a significant level of popularity. So whether it's, songwriter royalties in the form of mechanical royalties or performance royalties, unless you're getting streamed on, or unless you're getting played on commercial like radio, um, that the performance royalties aren't going to amount to much. Unless you're streaming heavily, then your mechanical royalties aren't going to amount to much. And the same goes for record royalties when unless you are, either selling a ton of physical product or getting amassing significant numbers of monthly listeners or streams, it's just not enough to maintain, a living. So synchronization opportunities where you use the song and the recording in an audio visual work. Most frequently, it would be television or film or a commercial of some sort. Of course, there are also nowadays there's sort of smaller synchronization opportunities on TikTok, Instagram, Facebook, etc. But the large money, the big paychecks tend to come from film and television and advertisements. Well, you don't have to be a known quantity. You don't have to be the most popular artist in the world to get a big check. In fact, there are plenty of independent artists who make six figures just on synchronization opportunities. And so that is something that's unique. And so a lot of people, focus on boosting their monthly streams, and I understand why. I mean that is indicative of a broad fan base, and you want to have a broad fan base because you want your art, your music to reach, the most ears possible. But in
Right.
terms of revenue, in terms of um, looking for ways to diversify that revenue stream, synchronization is a big one.
Yeah, and it's something that again, like especially with legacy artists where they're not having hits, but they had big hits way back when. They're not selling records currently, but that licensing thing is. And I worked with the Turtles, I worked with the Champs, the group that did Tequila. I've worked with a bunch of those artists, and there was always a bad story, almost always with them with their publishing and how it came down with the record deals. So it's so important for people to educate themselves on this in this area. And you release music, and of course we all hope that it's a hit, and you never know where that song is going to end up, so you need to prepare for the possibility that yeah, maybe it is a hit, and then down the road you want to protect yourself from bad ramifications if you don't take care of the front end of it. One question I wanted to ask, because I know you also work with a lot of artists, um, and we see a lot of information lately about people selling their catalogs. And we've seen some huge deals, huge financial deals. Can you talk about that and why artists do that? Well, what's the reason typically? I know there's a bunch of different reasons, but why they would sell their catalog?
Yeah, I mean the catalog sale market has, matured. It is, I think, a lot of the big catalogs have been sold. But the reason why those artists or those songwriters would do it is because the valuation that they're receiving, right? The way that those deals work is they typically look at the average of, let's say, the past 3 to 5 years of income. And then they apply a multiple to that number. And that multiple, you know, varies pretty significantly depending on a number of factors, which kind of gets into the weeds. But let's just say, for the sake of argument, that multiple can be anywhere from 7 to 20, right? And so you take the average of the last 3 to 5 years earnings and you multiply it by, let's say, 15. And to an artist or a songwriter, having that large sum of money and deploying that capital elsewhere, perhaps into other investments or what have you, may be more worthwhile to them than receiving, just check after check after check. And especially if you're still creating, and you're confident in your new material, right, selling off your catalog and then continuing to create, that would, ideally give you consistent revenue moving forward as well. We are seeing more partial catalog sales, or partial royalty sales, so where you're not selling 100% of your copyright or 100% of your royalty stream. So you kind of get the best of both worlds.
Hmm.
Hopefully, you can get a high valuation, but also maintain some revenue that's coming in the door from that royalty stream. So these companies, they're pretty good at extracting value out of particularly older catalogs. You like look at the Neil Diamond movie. I mean,
Yeah,
that like
huge. Yeah.
they're really good at coming up with new ways to figure out how to revitalize a catalog or to turn over money where there wasn't any. And so if you've maintained a portion of your royalty stream or your copyright, then you can be the beneficiary of that work too. And so I would say that those are becoming more common, but that's of course going to probably bring the valuation number, or the multiple down, the less that you're transferring over. But that's the essential rate. It's all financial. That's why. It's because they feel like there's more value in the upfront money now than there is in waiting around for that money later.
Yeah, and do you find also too that maybe sometimes their concern is for their family not having to deal with all that when they're gone, and it's just settled. Maybe that
Yeah,
could be a
absolutely.
motivation. Yeah.
We worked with a composer recently who was worried about just that. Had a long career and continues to have a career as a composer, but wanted to be able to provide for his family in a way that was pretty simple and uncomplicated.
Mm,
And there's nothing like a big, check in the bank to provide in a way that's not, complicated. And then if they manage that money well, then, you can live off the interest, right? Like that's kind of
right.
the idea. If that money is deployed in ways that can generate more revenue. But I think you're right about that. It can be about providing for your family in a way that doesn't involve having to track royalty statements. And I've got those clients too, where their parent was maybe a record producer, and they come to us and they've got just, I mean, hundreds of contracts that they're trying to sort through to make sure that they're being accounted to correctly. And
Right.
that's a real pain.
Yeah,
Um,
like overwhelming, and maybe they don't really understand the music business. They don't have the money to go out and hire a bunch of attorneys and fight labels, and it's yeah. I think that's been my case where when I've run into these guys and talked about them, and it just gets overwhelming. And they're kind of thinking, well, how are my family going to deal with this? They want to make sure they're protected, and their music's protected. They've already got their money out, so that takes a big weight off of them trying to chase down royalties, right?
Yeah, yeah, I think that's right. But it becomes somebody else's problem to chase down those royalties.
Exactly. Yeah. What's because obviously you're very experienced. You not only from just representing artists, but just in as being an attorney. What are some of a couple of really big points for younger artists and younger musicians that you like to tell, especially when you're teaching in class? What are some bullet points that you really think they need to pay attention to when they're releasing their music and to protect their music?
Yeah, I mean, one is don't pay for streams. There's way too many kind of opportunities that are put in front of independent artists these days that promise to boost your stream counts, because that's sort of the currency these days is
Right.
you look at, monthly listeners or stream counts or whatever. And if somebody's trying to catch the attention of a label or something, they want to make sure that their stream counts look good. And so they'll boost their numbers on social media or on streams, and that sort of artificial streaming is really being cracked down on. And so that's you can get your entire profile wiped out overnight if your distributor catches you, inflating your streams or purchasing streams in that manner. So that's one. Don't try for overnight success in that regard. It does. This is a business, and it takes time. You don't have true overnight successes. The people who you think are overnight successes have been putting in countless hours behind the scenes, where they're striving for success. So take the long view is one. My law partner always likes to say, follow your momentum. And I think that there's an incredible wisdom in that. If you see the direction that things are working, for whatever reason, and look, I'm an artist myself. I started out playing music before I ever became an attorney. So I have a certain appreciation for this. But sometimes, like, people say, oh, well, I want to go in a different direction. Our tastes change, or we don't want to be boxed into a particular way of that people perceive us. And so we try and fight against that, when really there's some real value in just following that momentum, and not fighting against it, right? So, like, swimming with the tide as opposed
Right.
to against it. And I think that there's some truth to that. Find out what works, and when it's working, run with it. But then, by the same token, don't you know don't be so blind to realize when that momentum shifts. Like, what you do to get you one place will not necessarily be the same thing that gets you to another. And so, be versatile, be flexible, but follow that momentum. And lastly, I think just be authentic. uh, I think authenticity in artists has always been valued, but I think it's going to become all the more so valued, as we move into an era of artificial intelligence, and where you've got music that is being created by bots. I think people want a real connection with their artist, with the artist that they follow, and being your authentic self is the only way to do that.
Hmm.
Anything else is going to be a time bomb. If you are not being true to your authentic self, then I think that you're not in it for a career. You may be in it for a minute, but it's not going to last.
Yeah, and I think that that's 100% true. And ultimately, if you're going to be successful, you want it to be because you are being yourself, and that's how you get authentic, long-lasting fans, I think. Tim, let people know how they can reach you if they want to find out more information. And also, you mentioned you're an artist. If you have an artist social media thing, I'd love to check that out as well.
And it's been a long time since I've been posting music, but
That's all good.
even if I did, I would try and bury it somewhere. But
Yeah.
uh, you can reach us at wellskappel.com. Wells Kappel is our law firm. My law partner is based out of Chicago. We've got sort of the middle of the country, a lockdown, although our practice is national and international in scope. We've chosen to make careers sort of in the middle of the country, outside of the coastal music
Right.
epicenter. So wellskappel.com. You can get in touch with us that way.
All right, awesome. And thank you so much for the information. You mentioned AI, and that I would ask you now, but that's such a big topic. And I'd actually, maybe we can revisit this in a month and talk about that specifically and have another conversation with you, because I know I'm sure you're getting a ton of questions about that right now these days, and inquiries about AI and how that's going to affect artists. So
You're
maybe we
absolutely
can,
right. That is a
yeah.
massive, that is a massive door to open.
Yeah, and again, there's a lot of amateur attorneys out there thinking that they know what the rules are and are not. So I think it would be important to talk about that. So maybe we'll do that again down the road.
I'd
But
be happy to.
awesome, thank you so much, Tim. Have a great day in New
All
Orleans,
right,
and
Jared.
I'm jealous of all the food you have down there.
Well, come visit, man. We'll save a plate for you.
I definitely will. Thanks so much,
All
Tim.
right, take care.
Bye.